attack judges. That's what they told us. Anyway, joining me now, Mike Davis, former law clerk for Supreme Court Justice Gorsuch, I should say, and founder of the Article 3 Project, Saul Weissenberg, Fox News contributor and former deputy independent counsel. Let me start with you, Mike. And I want to talk about this gag order. So Merchan partially lifts the gag order. So Trump can now address Stormy Daniels. He can address Michael Cohen. He can't talk about the jurors or family members. But this comes suspiciously timed 48 hours ahead of the debate. You know, was Merchan thinking about the debate here and the criticism he would get? What's going on with the timing?
These gag orders on criminal defendants are clearly unconstitutional. They're illegal restraints on First Amendment rights. If anyone in America must have the constitutional right to speak out against the judge, the prosecutor, the investigators, the staffs, the witnesses, it is a criminal defendant going through the criminal process. And this Judge Juan Merchan doesn't want President Trump to talk at the debate about how his adult daughter, Lauren Merchan, is raising millions of dollars off of this unprecedented criminal trial over which her father presided, requiring his recusal under New York statute. Instead, he retaliated against President Trump and said he would throw Trump in jail for mentioning this corruption.
Oh, but you can't talk about Judge Juan Merchan. You can only talk about Judge Cannon, Eileen Cannon. That's the only judge you can talk about. That's what they tell us. But moving on to this, your exact point, and it's a really good one, that this is unconstitutional in my mind. Saul, I saw this from an ACLU amicus brief, and it was in relation to the Judge Chutkan gag order. But I find it to be relevant to any of these gag orders. Here's what the ACLU, no friend of Trump, by the way, said. The obvious and unprecedented public interest in this prosecution, as well as the widespread political speech that it has generated and will continue to generate, only underscores the need to apply the most stringent First Amendment standard to a restraint on defendants' speech rights. They make the point that speech about these trials is inextricable from political speech in a campaign, Saul.
It's core political speech. It's protected speech. The standard the Justice Department wants the judge to follow is amorphous. It talks about substantial, imminent, foreseeable danger. If his words threaten that, he should be kept from speaking, President Trump, former President Trump. The other problem with it is there's no evidence of it. There's no evidence that anything he has said has endangered any agent. And one reason for that is that there's already been a court order redacting any agent's name. So we haven't seen the name of any agent who participated in the search at Mar-a-Lago mentioned, and that was with the agreement of President Trump's attorneys. So I think that's the problem with the order. Not only does it abridge core political speech, but it's an amorphous standard the government wants, and they have no evidence in support of it.
Now, I want to ask,
that's the problem with it.
That's a huge problem. I want to ask you both about this quickly. We have Wednesday Supreme Court opinions. They announced Thursday and Friday as well. I believe they have something around 18 opinions left. Everyone wants to see the immunity opinion and the January 6th opinion coming down. And it will be hugely different if it drops Thursday before the debate versus Friday after. When do you think it comes, Mike?
I think that the presidential immunity decision will come out on Friday, probably one of the last decisions the court issues. The court would normally probably issue the Fisher decision on Wednesday, but because of the debate on Thursday, they may wait till Friday for both.
And the Fisher opinion is the one that pertains to January 6th. Saul, do you agree with that? Do you think it comes after so as to not admire itself in politics, or is that just not a consideration?
Well, I'll defer to Mike on that. He clerked on the Supreme Court. I only got as high as the Second Circuit.
Pretty high.
But it certainly makes sense. I don't think they're going to be going out of their way to exacerbate the situation politically. They've already been accused very unfairly, in my view, of being political. So I don't disagree with Mike.
Well, the Second Circuit is no small potatoes. Mike and Saul, thank you very much.